Hello, my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about standard contract clauses and transferring data from the EU to other countries. Standard contract clauses is one of the three major ways that companies can transfer user data out of the EU to countries that do not have the same level of protection that EU data has when it's still in the EU. For example, countries like the US, Brazil, or India, if user data from the EU goes to those places, there has to be a mechanism by which companies need to make assurances to the EU that they are protecting data as they would if it were in the EU to some extent. So currently the three methods that companies can use to do this data transfer would be the US EU Privacy Sheild framework, which is a transfer from the EU to the US. Standard contract clauses, which can be used with any country that does not have currently adequate protection. And binding corporate rules, which is about multinational companies transferring data within their own company. So currently in July of 2020, there is a case that's been going on for many years that will have a very important hearing about what will happen with standard contract clauses. So standard contract clauses under this case, this is a Max Scherms case, who's the Austrian activist lawyer, brought this case to have the court be able to determine whether standard contract clauses provide adequate data protection for EU citizens. Max Scherms, in a previous case, they call that case Scherem II, he brought a case against, at that time, the safe harbor framework, which was actually invalidated by that case because it was deemed to not have adequate protection. Once it was invalidated, I think that was October of 2015, between that time, October 2015 and February of the following year, many companies were scrambling who were under the safe harbor framework because it was invalidated to find alternate ways to move data. So a lot of people went to standard contract clauses as opposed to using the Privacy Shield in the US. So that's why we have the Privacy Shield, and people are very nervous about it. Most companies use standard contract clauses. I think up to 80% who do these data transfers to other countries that have inadequate protection use it. So businesses are very nervous right now about what will happen in this court related to standard contract clauses. Several months ago, there was a non-binding ruling about standard contract clauses in terms of its adequacy. So some people were breathing a sigh of relief then, but people are concerned that in addition to standard contract clauses, this particular ruling in July may actually have some impact also on the Privacy Shield. So the issue is, if the standard contract clauses don't have adequate protection for EU data, what other mechanisms have to be put in place? So there may be some additional changes to the standard contract clause language, or there may be changes in terms of audit procedures for importers or exporters of EU data. So people are very nervous. Companies are looking at this ruling very closely. It remains to be seen what will happen. I think because of the current pandemic and the economic impacts that it's having around the world, it may be a situation where these things may not change, or if they do change, it may be to add a little bit more skin in the game for importers and exporters in terms of being able to prove that in addition to adding these clauses to contracts, that they're actually following through on this data protection. Thank you.